In this video, we're talking about the penalties for narcotic drug convictions. In a prior video, I explained a little bit more about how the statute works, but let's do a quick recap. So there are different penalties for different types of conduct, and if you're convicted of them, we have different levels of felonies. So as a reminder, Arizona, we have different classifications of felonies. At the very top, we have a Class 2. At the very bottom, we have a Class 6. And the statute, 133408, has different levels of felonies based on the conduct. So we'll run through those real quickly so we have a quick refresher on how this works. If you have a narcotic drug for possession or for personal use, you're only using it, it's a Class 4 felony. If you have it for sale, you're selling it to somebody else, it's a Class 2 felony. It bumps it up to the highest. If you have the chemicals or equipment to manufacture, it is a Class 3 felony. If you actually are manufacturing it, it's a Class 2 felony. If you are administering a dangerous narcotic drug to somebody else, it's a Class 2 felony. If you are obtaining a narcotic drug by deceit or by deception, that's a Class 3 felony. And if you have a narcotic drug and you're transporting it for sale, that's a Class 2 felony. So if you have prior felony convictions, it's going to be very important you understand what level you're at, because that's going to change the category of your sentencing. You're going to have to look to the Arizona sentencing chart to see where you may fall. But this video is more for people who have no prior felony convictions. We're going to be looking at what the law says is mandatory if you're convicted of these things. First and foremost, the law says that for numbers 1, 3, and 6, you can see here numbers 1, 3, and 6. So for possession and use, if you have chemicals or the equipment to manufacture a dangerous drug, or you are obtaining it by deceit, and you have no priors whatsoever, no prior felony convictions at all, you may be probation eligible. You are probation eligible. That's what the law says. You are eligible for probation, meaning you do not have to go to prison. You do not have to look at the sentencing chart and find where you are in the presumptive term under Category 1. You don't have to do that. You may be probation eligible. Now, probation doesn't mean that you don't go into custody. It just means you don't go to prison. So that's for numbers 1, 3, and 6. Possessing or using, having the chemicals, or administering it. Or, obtaining it by deceit. For numbers 2, 5, and 7, so for sale, for administering it, or for transporting it, if you're over the threshold, so depending on what the narcotic drug is, they will aggregate it. So they'll say, okay, we took it from this case and this case and this case, and we aggregated it. And if the total weight, the total volume, the total amount is over a threshold, it doesn't matter what your background is. You are not eligible for probation. So you will then need to look at the sentencing chart and see where you fall based on what level of felony you're at. This stuff can be a little bit complicated, which is why it's important to consult with an attorney, but this is generally how it works. Most people are going to be here in this number 1 category. For number 4, if you are manufacturing a narcotic drug, you cannot get probation. You just cannot get it. The law says in the statute 3408, no probation for manufacturing a narcotic drug. If you're convicted of anything under this statute, in terms of monetary loss, monetary penalties, it's $2,000 is what's owed, or 3 times the value of the drug. So whatever the value is, the street value, whatever the government determines the value is, it's 3 times the value or $2,000, whatever is greater. So they're going to penalize you as much as they can, essentially, monetarily speaking. And the judge doesn't have any authority to negate that. If you're convicted, you are not allowed to have any drugs. So if you're going into prison, you're not allowed to have any drugs unless they're administered by the Department of Prisons, or if you were out of custody by a medical professional, and you have to have a prescription in order to obviously get that drug. You will be on probation, so if you're testing positive, you're going to have mandatory testing as well for any of these convictions. So if you're testing positive, they can consider that to be a violation of probation. You can have a whole slew of additional penalties imposed upon you. You have to also do 360 hours of community restitution. This is if you are given probation, you have 360 hours of community restitution that you must complete. It's written in the statute, so it doesn't matter where you fall on this, you're going to have to do 360 hours of that community restitution. You will also have to do what's called SAS, a substance abuse screening, and follow-up treatment. So you'll be on probation for a period of time. Throughout that entire time, as long as your probation officer, the probation department want you to be on substance abuse screening or testing, they're going to make you do that. You're going to have to do the follow-up treatment in addition to everything else. So as you can see, the statute is a little bit complicated. A lot of this is going to be dependent upon your priors. It's going to be dependent upon the drug. It's going to be dependent upon the amount of the drug. A lot of it's going to be based on what we're able to negotiate out or what evidentiary problems or legal issues we can raise in order to make sure that this goes away and you get the actual absolute minimum possible. So give our office a call. We offer free case evaluations on these. We'll sit down with you. We'll look at your background. We'll look at the facts of your case. We'll make sure that we'll be a good fit together so that we can put together a good plan and ensure that you are not being convicted of a narcotic drug violation. Give our office a call. I look forward to speaking with you soon. Thanks for watching.